So let's go ahead and get started. I'm going to share my slides, and there we go. Um, so today we're talking about library service contracts. And we'll have a little bit of a different spin on it than we normally do. Here's my first slide, which is my disclaimer. Those of you that are familiar with my webinars have seen this before because I discuss legal issues, but I am not your attorney, and I make no claim to being your attorney. I have to have the disclaimer that says that, I am providing legal information, but you should always confer with your attorney when you're applying that information to your specific situation. Here's my contact information. If I can assist you with any questions on contracts or other matters, please don't hesitate to contact me. We also have a survey that you will be getting a link to in the email we send you next week. We'd very much appreciate it if you fill it out. We actually really do look at them. And what's really helpful about it is it actually helps me, well, it helps Library of Michigan know, how, whether or not we're being helpful, and a couple of the other questions that we ask you, like if you know how to contact us and all that kind of things. But it also helps me as a presenter. It helps me improve. So if there's something that you don't like or something that you've noticed that could be problematic, we want you to say it, so that then that's the only way, one of the only ways that really we can improve. I'm also always looking for suggestions for topics. So don't assume you're the only one struggling with something. If there's a topic that you would really like, gee, I really wish someone would talk about X, please let me know, because chances are if you have a question about it, so do many other people. And, I try to come up with, interesting things to talk about, but it's really helpful if I have, if anybody else has any suggestions. Okay, when we're talking about service contracts in libraries, there's a couple things that I want to get out of the way first. And one of those things is just a little basic background on state aid, because library service contracts are connected to state aid and connected to penal fines. And the reasons for that are because the way that state aid and penal fines are paid out they're paid out on a per capita basis. So if we step back and look at state aid for a minute, I'm assuming most of you know what state aid is, right? So it is an appropriation by the legislature under statute, the State Aid to Libraries Act, which provides money to public libraries in Michigan that meet certain qualifications, right? And so you have to meet that you're legally established, that you have 0.3 of a mil of local support for the population that you are servicing, and that includes populations in your contract, right? So if you're going to contract with a township or a village or a city, you need to make sure that your overall monies are going to be able to accommodate a 0.3 of a mil minimum that have to be attained for that population, right? So if you are just barely managing 0.3 of a mil for your existing population and you're looking to contract with another population, then one of the things you're going to be concerned about in your contract is making sure that you're going to be getting enough money to cover that 0.3 of a mil so you can get state aid for that group. And we're going to talk a little bit more about that later. You need to make sure your staff and yourself have the appropriate certifications depending on what your class size of your library is, and you have to fill out the application or the annual survey. So along with that, the way that this is connected to contracts, except, in addition to the 0.3 of a mil question, is that state aid is paid out in per capita. So what happens is once that money is allocated to the Library of Michigan from the legislature, and once Kathy Webb and Joe make sure that everybody is adequately, has adequately applied, is adequately certified, and that everybody meets the appropriate qualifications, then they look at populations. So Kathy Webb looks at the populations that each library is serving, and the amount of state aid given is then, there's a calculation that breaks down that lump amount of X millions of dollars into a per capita for population. So an amount per person of population. So if you are serving, 3,000 people, your state aid amount is the amount of per capita state aid, which I think right now is somewhere in the 46 cents, something like that. and you multiply that by your population, and that's the state aid that you're going to get. Well, if that population changes because you either get a new contract or you let go of a contract, then Library of Michigan needs to know, because that's going to affect your state aid, right? If you have 1,000 more people or 1,000 less people because of a contract situation, then that's going to impact the amount of state aid that you get. It also will impact the amount of penal fines that you get, because penal fines are also done per capita. You know, penal fines go from the courts to the county treasurers. Then the Kathy Webb submits to the county treasurers a list of all the libraries eligible for penal fines in that county and their population. And then the penal fines get divided by the population and to get a per capita amount. And then the individual populations served by each of the libraries on that list get multiplied by that per capita amount, and that's the amount of penal fines that you get. So the same thing, if you have an impact to your service area based on a contract, then that could affect your state aid, and that could also affect your penal fines. So where I'm going with this is that anytime you have a change in your contracts, whether you are gaining population or whether you are letting go of a contract, you need to make sure that the Library of Michigan is aware of this, in particular, Kathy Webb. So you need to make sure that Kathy Webb has information relating specifically to any changes in contracts. And then what happens is Kathy Webb applies those population changes to the database that we keep here with all of that information for people on state aid. And then that tells her how the amounts get calculated. So if you don't provide us with the correct information, then in the end, your penal fines and your state aid may not be correct. And that can have some consequences beyond just you not having the money you expected or having more money than you expected. Particularly if you have more money, then it requires, you know, some being paid back. It can require, it can cause some problems. You know, if you don't tell us and then you end up with extra money, that could cause some problems for you above and beyond just having to pay back that money. So it's just a very good idea that anytime you have a change in your contracts, you make sure that the Library of Michigan knows about it, and we're going to kind of reiterate that through. So that's one of kind of the background things that you need to know about contracting above just how contracts work. Is you need to keep in mind penal fines and state aid. And we are going to talk about some of that as we move forward, because there are some additional little details that when you're forming a contract, you're going to want to keep in mind. So the Establishment Act that you are under, depending on what kind of library you are, all the Establishment Acts provide library boards, or if you're a home rule city library or you're a charter township library, your municipal body, which acts as your library board, the laws provide the ability for these entities to contract on behalf of the library. So part of what the legal authority that a board is given in the Establishment Acts is the ability to bind the library to a contract. Now, whether that contract is with another municipality or whether that contract is with a, you know, with AT&T, the law gives the library board the ability to legally bind the library as an entity to a contract, which means that once the board signs a contract, the library is legally obligated to adhere to that contract and can be penalized if it isn't. So I have here on the slide a couple of examples of the specific legal sections that give that ability to contract in case when you get the slide you want to take a look at it. So we have the City, Village, Township Library, so PA 164, and then there's also specific municipality have the ability to contract as well. So that means a municipality can approach the library and say, we would like to have a contract for service for our people. Or two municipalities can get together and contract for a district library. So municipalities also have the ability to contract for different reasons. So let's talk a little bit about why you would have a contract, right? So why have a service contract? Well, most librarians that I talk to and most boards are, libraries are a community of very big-hearted, caring people. And most of us who are librarians have a passion for what we do. And we feel very strongly that we want to, provide this service. And the idea of patrons without access to a library, in very many cases bothers us and makes us want to provide service, particularly if you're in a community and there's an adjoining community that doesn't have service. So I've talked to quite a few librarians who ask me about contracting, and their main aim is to provide service, right? Their big objective is that we want to provide these people with service. There's a lot of district libraries in Michigan, and sometimes when a district library is formed, particularly if it's formed in a school district, there are little portions of the various townships or municipalities that make up the school district that might not be part of that school district, and so get left off of the district. So sometimes there's these little tail ends of populations who are not served. And there's very often adjoining communities where, maybe the library is closer. Maybe, it's more convenient for them to use that library. Maybe it's the library affiliated with the school district that their kids go to, as opposed to the other school district in their municipality. So, the objective a lot of times is we want to provide service. How do we help these people get access to a library? Then an additional issue, which has cropped up a lot this year, is money. Especially now, everybody's looking for money. Municipalities are looking for money. Libraries are looking for money. So there are many libraries out there looking to increase their revenue. And very often finding an unserved population not only allows the library to provide service to a group that doesn't have it, but it has the added benefit of hopefully also bringing in some money. And, for some libraries, it's just a matter of maybe not profit, right? So they're bringing in, they're just having a serve, equal amount. So the amount it costs to serve this population is the amount of money they're trying to get back. How do you increase revenue with a contract? Well, you receive state aid for that population. Again, if you meet the criteria, you would receive penal fines. And a side note on penal fines is that the municipality does not decide who gets their penal fines. Once you have a contract with a municipality for library service, you get their penal fines. It is not up to the municipality. So have been municipalities that have asked us, well, can we only give them a portion of the penal fines? Or can we, if they have penal fines in escrow, which frequently happens. So if you have an unserved area that has been unserved for many years, what happens is when those penal fines, so when penal fines go from the court to the county treasurer, and the population is calculated, they use the whole population to calculate penal fines, not just the calculation served by libraries. So not just the population served by libraries. So when they go to portion out the penal fines, they portion out to the populations of the various municipalities. So that means that a municipality that is unserved will receive penal fines, but because they don't have a library, there's nobody to take them. So that means that the penal fines go in an escrow account at the county treasurer, where the money just sits there until there is an agreement for library service. So there are some areas that have a little nest egg, if you will, of penal fines. Sometimes it can be a lot of money. Sometimes it can be not a lot of money. It depends on the amount of years. It depends on the amount of population. If a library makes a contract with that unserved area, the library gets that escrowed penal fines. They get them. If you're serving them, you get them. The municipality can't say, well, we don't want to give the penal fines to that library serving. They don't really have a choice. The only times the penal fines, they might be split, is if more than one library is serving a particular population. But generally, the penal fines would go to the library that is making the contract. So in those respects, sometimes you do get a little windfall of money over and above just what it costs you to provide the services. And then you have, additional payments. So this is something that, again, is starting to become a discussion recently because there are lots of library contracts out there where the original contract was just for state aid and penal fines in return for library service. And years ago, that may have worked out fine. But now there's starting to be a realization that if your legal service area, right? So what's a legal service area? Well, a legal service area is the population that your library is serving as a result of your original establishment. So if you're a township library and you were established as a township library, then your legal service area is the population you are serving in that township. Then you may have additional contracted service areas. But for purposes of your legal service area, so the idea is that if your legal service area, let's say, for example, pays a millage, okay, then the amount of money that your legal service area pays for service could be, some areas it's over $100 per household, right, per taxpayer. Then if a community that has a library where the taxpayer is paying $100 a year for a millage, but then that same library contracts with an adjoining municipality only for penal fines and state aid, so then that means that your legal service area is paying at least $100 per person. In addition, they're also paying state aid and penal fines, right? So there's also the penal fines and state aid for your legal service area. But then your contracted area is only paying the 40 some odd cents plus whatever your penal fines are, which could be anywhere from 74 cents or all the way up to $15, per person, depending on where you are. That's a big difference. So if you were in a store and you were paying $100 for, a pair of headphones, and then the person next to you came in and only paid $1 for those same headphones, you would wonder, right? Like, hey, why am I paying more for the same thing that this person is getting? If in addition to that, it was your store, then you'd wonder even more. So there's starting to be this question among members, legal service area citizens, as to why am I paying a millage and a large amount of money, but this guy from the next door, village or the next door township is paying a pittance or to what sometimes it looks like to them nothing, right? If they're just getting penal fines and state aid. So, a lot of libraries that I've talked to, they so much want to provide service that they overlook this, and if their population isn't causing an issue about it, then they may let it go. But because this is starting to become a bigger issue where members of the community may recognize this and say, hey, or boards may notice it and say, because boards are looking at money and may say, well, why are we charging this much to our legal service area, but then we're not charging very much for the same amount of service. So it's really a good idea when you're looking at contracts to make sure everybody's paying the same amount for the same service, or proportionate amount, right? So we're going to also get into that in a minute. So one of the options in terms of increasing your revenue is you can ask these municipalities that you're contracting with for additional payments, or you can require them to go for a millage in order to get service. In other words, hold them to the same standard that your legal service area is held to. So what are the steps to contracting? Well, the steps to contracting are, first you have to identify a group to contract with, right? You have to identify an unserved area or another group, to contract with. That other group can be a municipality. It can also be a school district, right? There's also a trend right now where some libraries are managing school public libraries. Now, there's not a whole lot of school public libraries out there. There's very, very few, but there's a couple libraries out there that have entered into contracts with school districts to manage that school public library. So usually a school public library is under the control of the school district. Schools are saying, well, we can't afford our school public library, so we're either going to close or we have to come up with another solution. And sometimes the solution is to invite a local public library to say, hey, will you come in and maybe treat this as a branch of your library? And then a contract is negotiated from there. Then once you identify a partner, then you have to kind of step back and say, okay, what is it that I want? And what am I going to suggest as the kind of the terms of this contract? So you would want to sit down and figure out, okay, what kind of money do I want in exchange for service? And what kind of services am I going to offer? So first, to have a stepping stone, you want to calculate what the current cost of library services to your existing patrons. How much are your existing patrons paying for library services, whether it's your legal service area and whether it's any other contracted areas that you have? You know, what are other people paying? So you have kind of a benchmark idea of an amount of money to start with this new possible partner. And then you look at your contracting options. What is it that we're going to offer and what kind of contract do we want to enter into? As we go through negotiations, what other options can we offer this partner if the first idea of we give you full service, you give us full amount of money, doesn't work? So there's different levels of service you can offer and different types of service you can offer. And then there's different amounts of compensation that you can request and different ways that that compensation can be paid. After you get that settled, and we're going to go into that further, then you would discuss, in your ideas, you say, okay, here's all the things that I can offer. Here's all the different money amounts that we're prepared to discuss or we're prepared to go to. And then after that, here's the services we're prepared to offer. Then you go to the potential partner and you say, hi, we would like to enter into a contract with you. Here's all the benefits we can offer you. And here is what we would expect in return. And then you go through the negotiation process. Once you come to some kind of agreement, you then have to look at drafting a contract. And hopefully by this time, you've already made a list of everything that you're going to offer and all of the services that everybody agreed on. And then you look at samples. You look at sample contracts that conform to the options that you've decided on. And this is the step when you probably want to talk to your attorney, if not sooner. Having an attorney in the negotiation process can be particularly helpful. So if you are willing and able to do that, you may want to contact your attorney before you contact your possible partner, and have your attorney contact them to do the negotiating. But if you either don't want to or can't do that, then the time to bring in your attorney would be at the time you're going to actually draft the contract. You can look at a lot of, at minimum, you want to look at some samples to see, how different contracts look and the different kinds of language that should be included. Then after that, after you have a contract in place and it goes back and forth between the two partners with different amendments or adjustments, when you finally have a sample, a finalized version everybody agrees upon, then it's time for the finalization, which would be signature. And then once it's signed, sealed, and delivered, then you want to make sure that every so often you review it, because things change, laws change, circumstances change, budgets change, populations change. So then you want to make sure that your contract is reflective of the actual services that are being given. If you just let a contract languish for 10 years, then you may find at the end of that 10 years, the library is really paying out of pocket maybe to provide service to this people. And that's not something that is advantageous for the library. So we're going to go into this a little bit more deeply. So let's talk about identifying potential partners. How do you do that? Well, there's the obvious ways where, you just kind of know. You have patrons that come in who are from other areas and say, gee, wish we had library service. And wouldn't it be nice if we could please, come to this library? So, you can talk to any patrons you have who have non-residency cards, right? Why do you have a non-residency card? There could be lots of different reasons, but one of them might be that their home library doesn't have library service. Library of Michigan, Kathy Webb, maintains an unserved area list. And I have a picture of that in the next slide, where it goes by county, and it gives a list of all of the municipalities that do not have library service. And then as there are contracts formed, she crosses them off the list. As contracts may terminate, she'll put them back on the list. And then you also have word of mouth. You might hear about a municipality, or you might have a municipality contact you and ask about it. So when you have a contract, when you're considering a contract, or you're considering locating a partner, or you have someone contact you, things you want to consider about, before you decide to approach a partner, before you get into discussions, one of the main things you want to consider is, where is this partner? Because there could be very attractive partners that are unserved. But if you look at where your library is, and you look at where that unserved area is, even if it's in the same county, it might not be convenient for the people in that unserved area to get to you. And if the distance is too far, then the Library of Michigan, we would have an issue with it. We may question the contract. So it's which doesn't necessarily mean you couldn't do it, but it would kind of throw a little bit of a wrench in your plans. I mean, we don't really have the power to absolutely say, no, but it would bring up some conversations. So because obviously you want to contract with a situation where most of the people in a particular area would reasonably be able to come to your library, right? Not just maybe 10% or 2% of the population. You also have to look to see whether they are already spoken for. There may be patrons, there could be a lot of patrons that want to come to your library, but they may already be contracted for another library. And maybe that other library is a little farther away. Maybe that other library is not as big as yours. Maybe, there could be lots of things. But if they're already spoken for, then that also can complicate things, because we can't have a situation where a library gets penal fines and state aid. More than one library gets penal fines and state aid for the same population. So that's important to understand too, is that, if you have a population that's already spoken for and is already under contract with another library, then that's a different discussion, right? You may have to talk to that other library about maybe releasing some population. There are circumstances here in Michigan where we have two libraries that serve the same population, and then they make an agreement between themselves. The two libraries have like a separate agreement, and library A, who gets the penal fines, then shares some of those penal fines with library B, who is, serving some of the population. So in areas where you have two libraries close together, where, population may use both libraries, there's a lot of situations where libraries will share the penal fines between each other, since, both of them can't get it. And that's a discussion you would have with, your fellow director at the other library. And that's a discussion, particularly if you are serving a lot of people from a neighboring area that is covered by a library. And then, and it may be that your population is also going to their library. So it can be beneficial to both institutions to have that discussion and figure out if they need to have some kind of sharing of penal fines. So your unserved population list. So this is just an image of the list that Kathy Webb has. We can make this list available to you. It is a public record, so all you have to do is ask for it. As you can see, it's a little tiny, but it's by county. And then like here, I'm trying to see the biggest one here. Right on this small list here, it looks like Clarence Township has almost 2,000 people unserved in Calhoun County. So, if you're in Calhoun County, that may be an option for you to consider. Now, just because the populations are on this list doesn't mean the municipality wants library service. That's a whole other story. Sometimes you have to be very creative in convincing them. But these are populations that are available to attempt to sway to have a contract with you. Once you identify your population, now we're talking about calculation of cost of services. And this very often is a very difficult section for a library that I talk to. And there isn't just one way to do this. And, I would suggest that however you have calculated your non-residency fees, if you have a non-residency card, that would be one way to do it. The other way is look at what your legal service area pays in a millage and just take that amount, and then everybody's paying the same. You could also, if your legal service area is paying, $500,000, then you can calculate what $500,000 would be per household in the neighboring municipality. You take their taxable value and multiply it by the mill, and then you get the amount of mill that per household. So, then you get the mill, you take even for me, this gets complicated. Never was a math major. So you take the taxable value and you multiply it by the mill. Then the amount you get, you divide by the number of households, and you get the amount of per household millage. So, or at least, a good estimated amount. And that's a proportionate amount. So if you have two areas right next to each other, and maybe your legal service area has a much higher taxable value, so the millage amount is much higher, than when you go to the area you want to contract with, and there is a much lower taxable value, then the offer you're giving them is, okay, you're paying the same as the legal service area. In other words, if you were to have a millage the same as our legal service area, a 0.5 millage, then this is what you would pay. So that way, if a member of your legal service area comes in and says, why aren't they paying the same? You can say they are paying the same. They're paying the equivalent of a 0.5 millage, which is what you are paying, a 0.5 millage. You can, or as I said before, you can have them pay the exact same amount. You can also calculate your services based on your budget. So you can look at the amount of expenditures you have per year and divide that by the population, and then figure out what that per person cost would be. Again, this often comes out to be a little bit lower than millages, so there's a good and a bad part about that. It's good because it might be attractive from a negotiating standpoint, but you still could get complaints from your legal service area. Look at your other contracts. So what do your other contracts say? As far as what people are, what has been agreed to. You can also talk to libraries around you and see what are they charging for contracts. Then again, look at your non-residency card as well, because part of this, if you're really going to kind of jump all into the contracting, and you're going to say, we want to make sure that everybody who's getting services from this library is paying approximately the same amount, but your non-residency card only costs $25, then someone could just walk in your library and get, for $25, the same service that your legal service area has for a millage of, up to what, $100 or more. So those are all the things that you kind of want to consider before you land on, this is what we would expect to make from this, from this agreement. Now, does that mean that you can't contract for just penal fines and state aid? No, because in the end of the day, a contract is between the parties. So you can agree to whatever your board thinks is fair, the two parties can agree to, and whatever the municipality thinks is fair. There's nothing that says you have to contract for the cost of services rendered. The problem really comes in when you have members of the public who walk up and say, why am I paying all this money and they're not? And you may think, well, no one's going to really know. And that's true. But there's a saying we have here at the Library of Michigan, which is nothing's a problem until it's a problem. So in other words, all it's going to take is one person noticing, and then you could end up, with a problem. And if that time period happens to be when you're going for your next millage, that could cause you some issue. So those are just some things to think about. You all know your area is the best. You know your community is the best. This may not be an issue for you, or it may. The other thing to consider that, if I put my legal hat on, the other thing that I would suggest considering is, part of the whole idea of public funding and managing public funds correctly is the idea that equal costs for equal goods, right? So if the library, which is publicly funded, is giving its assets or providing services, then the expectation is that they're getting the value back, right? Otherwise, it could be like they're providing services for free. Right. So it's kind of like if that's not the intent, and again, your legal service area is paying, then there could possibly be some someone could claim that you're giving state credit without unfairly. Now that might be a reach, but it's something that you may want. It may be something that you could talk to your attorney about. That might be a negotiating tool that you say to the partner, look, we can't give this to you for only penal fines and state aid, because that would be giving state assets or municipal assets away without receiving equal value in return. And that is a problem with the state law on giving state credit. But that would be a question to talk to your attorney. And as with any negotiation, it's like a dance. It's you have to kind of pick and choose what you're going to say and what you're not going to say. So then your next step is to determine your contracting options. So what are my options in contracting? What kind of contract can I have? Well, as I said before, a contract is between two parties. And so there's all kinds of options. You can be creative. There's a few things you have to think about, right? So some of the contracts currently in force here in Michigan are, we have full service for penal fines and state aid, which is very basic, right? You can have full service for penal fine state aid plus the requirement of a millage. If your legal service area is paying a millage, you could say this cost service is only going to be rendered if you're successful in getting a 0.5 millage or the same millage. You could do full service for penal fine state aid and a lump sum of money. This is a fairly popular option. You could say to the municipality, okay, look, we've calculated that this is the amount of money that if your area was going to pay a comparable amount or a proportionate amount to what the legal service area pays, and what the services are worth, this is the amount of money we would expect. So it could be penal fines and state aid plus X number of thousands of dollars, either paid all at once or paid twice a year or paid monthly. There's all different options there. You could say, okay, we're going to offer full service, but we want plus per capita service costs. So we've figured out what it costs per capita for our library service. That could be the millage amount that your legal service area pays. And we're going to multiply that by your either taxable household or by your population, depending on whether it's the millage cost or whether it's an individual. We've taken our budget and divided it by the number of people in the municipality. And then that's what we would expect to be paid. The other option you have is you can go for tiered service, and this is becoming more popular. So tiered service would be a contract that says, okay, municipality A, we will give your citizens basic service. So basic library service, which would be, and usually, you'd enumerate exactly what that service would be. So borrowing, use of the library meeting room, all of the things that traditionally you would get if you were a member of the community and you walk in your library, right? So ability to check stuff out, ability to place holds, all of this things. Then if your citizens want access to a higher level of services like Hoopla or Overdrive, or they want to be able to receive materials via Melcat, not Melcat, then they would have to pay an extra amount, or the municipality would have to pay an extra amount. So the idea is that you get basic services for penal fines and state aid. If you want the same, all of the services that our legal service area gets, then you would have to pay penal fines and state aid plus another agreed upon amount, which could be a discounted of your non-residency card. It could be a specific amount that you designate, by subtracting penal fines and state aid from the service area, from the amount your service area pays. There's different ways to calculate this. And you can say either the municipality pays it, which happens for some libraries. What happens is they send an invoice to the municipality either once a year, twice a year, quarterly, however they work it out. And that invoice says, okay, X number of families or patrons have signed up for the expanded access in this time period, and so this is what you owe us. Or the onus can be on the individual resident. So, for example, if I'm from municipality A, and the library in municipality B has contracted with municipality A for to give service, and the contract says that you get basic service for penal fines and state aid, but if I want access to some of the higher level services like remote database access through Overdrive, or the ability to download books and all that stuff, I would have to then pay myself an annual fee. And that's a very popular option, because that gets the library the additional money that they need in order to make sure everything is equitable between legal service area and that they're also being paid for services they're rendering. And it lets the individual taxpayer make a choice. Do I want to pay that extra money or not? So that actually tends to be fairly popular, especially since very often that amount that the taxpayer has to come up with is usually not giant, and it's like for a year. So that's an attractive option that has recently been done, and so we have contracts that are samples of that too. So as you can see, you can have a little bit of creativity with this. Again, it's about what the two parties agree to. The one thing you have to keep in mind is that if you receive penal fines from a population, the expectation is that you are giving them some library service. So you cannot take penal fines and offer nothing, right? So you can't say, for example, you can't have a contract that says, okay, we're going to get penal fines and state aid, but the only people that get library service are individual residents who come in and pay this individual fee. So the penal fines and state aid give the residents the option of paying, a discounted fee for service. That's not going to fly. You have to offer some service for penal fines and state aid. And so that's why we say basic services for penal fines and state aid. Then once you come up with your ideas, you come back to your partner, and now this is when you start negotiating. You can have a sample contract, a proposed contract that you give them. You could have a presentation that outlines different options. It all depends on the context, depends on who you're talking to. It depends on what has been discussed before. It depends on the individual circumstances of your individual library and the culture of the communities. But this is when you start really kind of talking and getting into it. Part of this is you documenting what it costs to service, because chances are the municipality is going to say, well, how do you arrive at this figure? And how do I know this is really what things cost? You can provide them with information from other libraries. Here is what X library, which is, you know, the next town over, this is what they charge. What you offer. We have excellent services. We have excellent programming. We have reciprocity with other libraries in the area because of our co-op. We have all these other services because of our co-op. You know, you can really kind of spotlight, this is what sets us apart, and this is the things that, this is the value you're getting in return for what you're paying for. You can also show them that, you know what, studies show that if you have a library, if you're independent, if your area has library service, then it increases your property values, right? People like to buy houses where there's library service. There's better student engagement and there's better literacy, right? Reading test scores tend to be better in areas that have active public libraries. You can enlist potential patrons from that area. So if you've had non-residents or you've had people coming into your library from this other municipality saying, boy, I wish we could have access to this library. We don't have library service. Use them as ways to petition their municipal government to work with you and to get a contract. That's very reasonable. Get them to write letters, get them to go to public meetings and support this, because that would be very powerful to the municipal government to say, okay, well, we know people want this. And then, you know, you want to be careful about, as much as you and your librarian hearts may say, look, we just want to offer service. We feel bad for this community. They come in all the time. They're really good people. We want to give them service. At the end of the day, that decision rests with the board and with you. But from the issues I see, I would say you want to be wary of settling for a deal that significantly undercuts the amount of money that your legal service area pays. And I cannot emphasize this enough, because it does cause issues, and it could cause significant issues at the time when you go to get a new millage. So then after you have discussions and you have kind of a agreement, okay, this is what you all have your notes as to what you agree to, then it's time to actually draft the language of the contract. Now, by this time, you may have a proposed contract that's been marked up and been changed around. Now it's time to kind of take that and formulate it into a final contract. This is when it's a good idea, if you have not gotten your attorney involved before now, this is when it's a good time to bring your attorney in. And the reason for that is it's important to remember that contracts are all about language. It's all about words. And contracts are really more of an art than a science. And there's ways to draft contracts that are really helpful and really good. And there's little things you put in there that a lot of people who don't practice in this area might not realize are really good to put in there. Especially when you're dealing with libraries. So I strongly recommend that you can use the best sample in the world, but once you have what you think is perfect, before anybody signs it, have your attorney look at it, because they may end up making some very excellent suggestions that could save you a lot of trouble or a lot of money in the end. Where can you get samples? I have a whole bunch of them of all different types. I'm happy to share. I'm sure that, you know, you can go to your colleagues at other libraries and ask to see their contracts. Contracts are public record, so they're not secret. You can also ask your attorney. You can say, hey, do you have any samples that I can view and see what they look like? You also want to make sure that crucial elements are in the contract, right? You want to make sure that your contract has all of the required elements that contracts should have, not only under contract law, but for specifically libraries. And this is another reason why it's great to have your attorney, because then you don't have to worry about this. So a basic contracts law class. So contracts language in law has a few different terms. So you have offer, consideration, and acceptance. Those are the three things you learn in law school that are the basic components of a contract, of a valid contract. So an offer is, you know, hey, we'll give you library service in exchange for, you know, money or in penal fines and state aid. The consideration is the payment. It's the penal fine, state aid, and whatever other payment you want. Acceptance is everybody saying okay and signing on the dotted line. Now, if you want to get complicated, there can be other kinds of acceptance. But for purposes of the class today or of the discussion today, it's signature, right, is what you really want to concentrate on. But there's some other things to consider. Authority, right? So authority is who has the legal power or the legal authority to bind the entity to a contract, and who has the legal authority to speak for the entity. In other words, the negotiator at the table has to be vested with the authority to offer the deal, right? Or to accept the deal. So whoever is negotiating for the municipality has to be somebody representing the municipality who has the authority to make these offers and to accept offers that the library is given. The library, usually the library director, but often a board member would go to, has to have that authority as well. So this is why if you're a library director and you're going to be discussing a contract with the municipality, make sure your board knows about it before you do it. To make sure that you have that authority granted to you by the board, because under the laws, the director doesn't have that authority on their own. The director is granted that authority by the board. The board is the one that's vested with the legal authority to represent the library. So it's important that, you know, you notify your board, you know, unless your employment contract or your employment description specifically says that you can represent the library. You want to, you know, make sure your board is notified that you're doing this. And then their agreement pretty much gives you kind of that authority. You want to, and then signing is a whole other thing. Okay, so when it comes time to sign the contract, that same authority applies. And this is why that for the Library of Michigan, when we receive contracts, so when Kathy Webb gets a contract, usually she'll give it to me. I'll look it over and make sure there's nothing glaringly that looks like a problem. And if I see that only a director has signed it, and I don't mean only because, you know, I'm not denigrating a director, but it's more because if I see just one signature there, I will usually go back and question that, because what we want to see usually is a board member and the director sign it. So again, unless the director specifically has that designation or that authority to sign that contract or to sign contracts and bind the library, that's going to be important. You want to make sure that the appropriate people are signing on both ends, on the municipal end as well as on the library end. So for example, a secretary shouldn't be signing for the municipality, or a you know, just the treasurer, or that, you know, you want to make sure that whoever signs has that authority. And it's okay to ask that question. And again, if you're working with your attorney, that is also something that your attorney would most likely ferret out as well. So then there's also, as far for a valid contract, you want to consider a meeting of the minds. And what the meeting of the minds is an understanding. So meeting of the minds in a contract means that both parties who are negotiating understand what is being talked about. And when a final deal is reached, each party is on the same page. So that's why a lot of times you see contracts where things are all spelled out. That's why they seem so long, because you want to make sure that both you and your municipal partner are both thinking of the same thing when they agree to this contract, that they both completely understand what the expectations are, what the services are, what the services mean, and how much money will be given or compensation, and how it will be given and when it will be given, so that everybody is on the same page, so there's no misunderstanding. you want to make sure that everybody's on equal footing, right? So you don't want to have a situation in a negotiation where you have, let's say, for example, you have the mayor of a municipality or the, township supervisor or the county attorney sitting in front of the library director and negotiating, and one side is bullying the other side, right? You want to make sure that both parties are in an equal representation to each other, right? So that there's no sign of coercion or bullying or forcing into a particular contract, that both parties are willingly and knowingly entering into this contract, and that either party feels comfortable in backing out or in not entering into the contract. Then you usually want the contract in writing, right? This in the old days used to be called a formality, which, you want to make sure, you hear about like handshakes, right? Or oral contracts. Well, the law evolved from that into making sure everything is written down. So you have proof, right? Because then if something happens and someone's not holding up their end of the contract, you want to have documentation that says, look, this is exactly what they said they would do, and they're not doing it. Whereas if it's verbal, now it's all about he said, she said, or she said, she said, or he said, and there's no he said, she said, and there's like, it almost has to go to court to be proven as to what actually happened. And so, okay, where am I here? Okay, so those are the kind of the basic things that you want to make sure your contract says. You can have oral contracts, you can have digital contracts, but I strongly urge against oral contracts. You really want a written contract. It would be difficult for us to give you penal fines and state aid based on an oral contract. You want a digital contract is still a contract in writing. So, that's still, a lot of times that is okay. It's also, using digital signatures. So again, that would have to be an agreement between both parties that digital signatures are acceptable. And the mechanism you use to do it would have to be, you'd want to consult your attorney and make sure that it's secure and that it's something that, would be accepted if anything were to come up as a conflict. But that can be done as well. Okay, so now that you know the things that should be in a contract, the parts of a contract, there are certain components specific to libraries that you want to look at. So in your contract, you want to make sure you're using clear language, right? You want to make sure you understand what services are you offering, for exactly how much money, and as I said, how that money is going to get paid and how often it's going to get paid. Is it going to be electronically transferred? Is it going to be a check? How is this going to be given back to the library? If you have to, you want to make sure you identify the population. If you're dealing with only a portion of the population of a municipal area, make sure that's properly described. Population not part of that school district, or population that lives in this particular area, so that you then there's no misunderstanding that other members of that community are not going to be offered this same service. If there's any exemptions to this deal, if there's anything, any part of population or anything that could affect a person's ability to get this kind of deal. The expectations of both parties, again, this will be paid on this day. Service will begin on this day. This is exactly the service that you will receive. This is how, sometimes you could also include, this is how the patron will prove they're from this area. And we talked about payment due date and method. Then also, who are the parties, right? You always want to make sure who is the contract between. You want to make sure that that's all clearly laid out. The start and end date, and this is very important. When does this contract start and when does this contract end? You can have automatic renewals. A lot of you may have contracts that say, if neither party ends this contract, it will, after the first year, it will continue until a party ends it. And ends it 6 months in advance, or however you decide you want to do it. You can also put a finite date on it. So this contract is good for 5 years. There's pluses and minuses to both of these. So it really depends on the situation and what both parties prefer to do. The one thing you want to make sure is that you keep in mind the penal fine date. Penal fines are so the penal fine date, the date that the Library of Michigan uses as the date that, Kathy calculates the list of libraries available for penal fines, right? Or eligible for penal fines. So the date, the cutoff date for her to deliver that list to the counties is June 30th. So whatever library is serving the population on June 30th is the library that will get paid the penal fines. So if you have a contract that ends May 31st, then you will not receive the penal fines for the service you provided for the whole preceding year. So I'm going to say that again. If you have an end date before June 30th, then your library will not receive the penal fines for that population, because whatever library is serving the population on June 30th of a given year is the library that receives the entire year's worth of penal fines. So that's why when you look at your contracts and you look at the ending date, a lot of libraries end their contracts. They'll begin their service on maybe July 1st, and they end their service at midnight on the 30th of June. So that then they are serving that population on June 30th. So if you like to go by your fiscal year, that's fine. Just make sure that you're covered for that June 30th date. Make sure you have a termination clause, right? What if you have to get out of it? You never know what's going to come up. You never know what's going to happen. So, both parties, there should be an out, right? There should be an out for getting out of the contract. And that can be all different things. There's, it can be, if you terminate this contract before X years, you have to pay this much. It could be, we need 6 months notice. So again, you want to consider the penal fines with this. So, if you want to make sure you give yourself enough time, and the 6 months kind of does this, that you would be serving them on this day. You want to make sure that if the contract is to be amended, so while the contract is going on, is there a way that either party could amend it during the course of the contract? And of course, and how would that be done? And usually, if you're going to amend a contract, the other side would have to approve it. So, but, it may be handy that you want that ability to amend it, because again, you never know what's going to happen. Again, make sure that the payment listed there is adequate and appropriate, and that everybody's appropriate signatures are on it and dated. So you want to make sure that all of those are the things that are the most important things you want to look at and make sure are there. Once you've done all that and you have your final contract, you're going to submit it you're going to make sure the library board sees it and signs off on it. Hopefully a library board member signed it, but if the director has the authority, the director, can sign off on it, but then you want to make sure the library board knows about it. At the end of the day, if there is any kind of lawsuit, the board would be involved. So you always want to make sure that the library board is informed and understands and has a chance to weigh in on these matters. You want to make sure that or actually this would be before signature. You want to make sure that a final copy goes to the partner for final review, that there's nothing last minute that they need to change or amend. And then if they do want to amend it, you fix the revisions. And then after all of that, you would submit the final copy for signature and the appropriate parties would sign it. I apologize, I shouldn't have put that signature line on the slide before. Then after all of that, so once you're completely done, you send a copy to Library of Michigan, to Kathy Webb or to Randy Riley. for Library of Michigan to make sure that we make the appropriate changes to your population. To make sure that, you know, either we're adding population, or if it's a termination of a contract, we are removing population. So the same token, if you terminate a contract, if you cancel a contract, make sure you let us know as well. Make sure you review your contracts periodically. So once you're all done, you're not done. Every few years, you should be looking at your contracts, knowing when they're going to expire, making sure that if laws change, if circumstances change in the library, if taxable values significantly change, that the library is being still appropriately compensated for their services. And also, as time goes on, the library may tweak how they do it. You know, you may come up with a better idea, or you may come up with a better system or different services that you'd like to offer that you want to make sure are in the contract. Lastly, you want to make sure you read your contracts. And I know that this sounds obvious, but if you're a new director walking into a library, and by new, I don't necessarily mean that, you know, you're fresh out of library school. I mean, if you are going into a new position, whether you are fresh out of library school or whether you're seasoned, one of the things you should do, among the millions of things you have to do, is review the contracts that are in place for your library. Make sure that you are aware of what the contracts say, and not just because someone told you, but that you've read the actual contract. Because as I said, contracts are all about language, and the language in contracts have significant meaning. So if there's ever a dispute, the courts are going to look to the contract, not what someone said was what happened at the time the contract was negotiated. They're going to look at the actual words that people signed off on. If you read the contract and you have a question, but you think, oh, it must be this, it just must be me, I must just not be understanding what this is. No, always ask. If you have a question regarding language in a particular contract, or something doesn't look right to you, whether it's a contract that you're negotiating or whether it's a contract that your library has already signed, ask. Investigate into it, because you know, chances are, if you have a question, there might be something there. And this could be an opportunity for you either to amend a contract, renegotiate a contract, or amend it before it gets signed. So always act on your instinct. Okay, ask. You should always ask before signing a contract. Review all of the dates in a contract very carefully, when it starts, when it ends, and that penal fine date. Double check your money and your figures, because mistakes do happen. Mistakes do get made. Typos get made. Always double check that. Double check the list of services. I can't again reiterate the idea of reading. Never sign a contract without reading it thoroughly. That may sound stupid, but people do it. There's an interesting kind of funny story that goes along with this. So in the upper right hand corner of this slide, you see I have this kind of weird list. So there's a rock band, a famous rock band, had a reputation for being kind of, you know, prima donnas, right? And so the allegation was that they required that they had a bowl of M&Ms, but that bowl could not contain any brown M&Ms. So the brown M&Ms all had to be picked out. And so, you know, they were widely ridiculed for this. And at one point in time, you know, people used to make fun of the excesses of some of these celebrities and their, you know, weird quirks. And then it came out, one of the rock band members wrote a book and about, you know, being in the rock band. And what he said was the genesis of this provision was that, so this particular band was one of the first bands to use complicated staging equipment and pyrotechnics and that kind of thing. And their equipment was so large and so heavy that it needed a very specialized setup, and it needed stages with certain weight capacities. So this contract, they put that clause in the contract to ensure that that the promoter or the venue would really read the contract. It was a way for the band to know whether or not the venue paid attention to the contract. So that if they walked in their dressing room and saw M&Ms with brown M&Ms in it, then they knew that most likely the venue did not really read the details in the contract. And that at that point, they would go and double, triple check their stage setup and address this issue with the venue and make doubly sure that everything was safe. They wouldn't take anything for granted. So it was, that kind of makes sense, right? But that's kind of a lesson in making sure that you read a contract and that you read it carefully, because different, it could be that you're missing something that's very, very important. And so both, anytime you come in contact with a contract, it's very important that you read it very carefully. And if you don't understand it or you have a question, ask it. Ask of your attorney, ask of the other party that signed the contract, ask, because that in the end is going to be very beneficial. Okay, so next month we are going to talk about employment law, and particularly employment law in the age of COVID and what's going on right now. So I look forward to y'all hopefully joining me for that. These slides will be provided to you early next week when we send out the email. And I'm going to see if we do have a few minutes for some questions. So I'm going to stop my share and take a look in the chat and see. Okay, with a decrease in population, many of us may see a decrease in state aid payments. Right. So even though what will happen is, I'm not sure when. I think it is going to happen around 2022. I was just asking Kathy Webb about this. So what has to happen is the Treasury, Michigan Department of Treasury, is where we get the population numbers from that we use, right? So that tell us how many people live in a particular area. So what we have to wait for the Department of Treasury to verify the numbers and give them to us from the census. So we expect that would happen. The numbers will be active in 2022. So depending on when we get those numbers and this, the state aid reports, and that's kind of when the population numbers probably would change, but we have to wait for those numbers to come in. So as far as timing, it's difficult for me to say. I can tell you that as soon as we know, you'll know. But yes, once all of the new numbers are in our system, some libraries will be getting less money or less, because they have less population. The calculations will be made using the lower population numbers. Some areas got an increase in population and they will see an uptick. So that's correct. Some people will see a change because of the population issues, in addition to with penal fines, some of the lingering COVID things, and some of the other things that affect penal fines. But we will make sure that as soon as we know. Can a tribal entity be a partner? That's a good question. Theoretically, yes. As a tribal entity can contract. The only thing I have to double check is whether you can get state aid and penal fines for a tribal entity. So I can certainly double check that and see and get back to you, because I see who asked that question. Is there a link for sample contracts? There, you can just, if you Google it and put in the word Michigan, you do get some. I keep a package, like I keep several of them. I don't have a link to them, but I have them digitally, and I would be more than happy to share them. I'm not sure about creating a link for them because you know, some of them I give out all of the ones I have that are a particular type that the library director asked me for, or the board member asked me for. But you know, some of them might be better than others. Some of them might be more applicable to certain types of libraries than others. And so it gets difficult to just post them for everybody. The concern is a little bit of, you know, we can't like actually endorse that all of these are going to be perfect. I always tell people when I share them that they're meant just for reference, and you want to take, you know, look at them, but always double check with your attorney. So I don't know of a site that just has blanket you know, library service contracts. I do know that if you search them, you do come up with some. And any, you know, they are public record, so you could request them from any of your colleagues. If I do find such a link, I will let you know. Let's see. And again, I'm happy to share them. Library has contracts with township that are very old. What really depends is the language of the contract. If the contract has some kind of ending on it, then it could be that they're no longer valid. If the library has changed its name, it's a gray area. A lot of what would depend on is, remember when I said that, you know, there's you know, when contracts could be you know, digital, or there is a area of contract law, and there is a contract, you know, a doctrine in contract law that pretty much says that if two people have a contract and the contract ostensibly ended, so you have a contract that may have a date on it that ended, but the two parties are continuing to follow the contract, then there is legal authority that shows that then that contract is still in effect. So it is more likely that your contracts are not invalid. A lot of that depends on, you know, how the contracts were written. They could be invalid for a different reason. If your contracts are really, really old, it's probably very much worth digging them out and going to renegotiate them for, you know, an increased amount of money, or for money if they're just penal fines and state aid. I definitely encourage every library to do that because nowadays, you know, it's just times are tough, and every library deserves to have fair compensation for the services that they're rendering. Okay, I think that was everything. If anybody has anything else, they can add it, or you can just unmute yourself and ask it. If anybody has any questions about a particular contract, don't hesitate to contact me. I'd be happy to talk to you. And again, I'm happy to share the things that I have. And that's pretty much it for today. Thank you very much, everybody, for coming. We really appreciate it.